So I was hired by a client who unfortunately fell, tripped over a very hazardous walkway. And unfortunately for her, she suffered significant injuries. She ended up having several surgeries on her back. A central question in trip and falls or slip and falls is, did the person that owned the property have noticed that the condition was defective? Was the walkway in the condition that it was at the time your client fell? And did they know? Did the property owner know about it? Or should they have known about it before? It's always a central defense. It's a question that needs to be resolved before the case can be tried successfully for a client. It's probably the central figure following a slip and fall. Certainly wasn't whether my client suffered these injuries as a result of this event, right? That wasn't the issue in this case. So of course, the at-fault party, we sue them. They deny it. They deny all allegations. No, we've had no prior notice of this event. Your client just didn't know where she was walking. This was totally a new event for us. Okay. Thankfully, we didn't take them for their word, so move on. I take the deposition of the person with most knowledge of the maintenance for this particular defect. Not uncommon. We do that in every case. So I'm deposing this guy. Now, mind you, they, meaning the defense, has already answered in written, sworn responses that no, we had no prior knowledge that this crack had existed. Absolutely zero. Yeah. I'm taking this guy's deposition. I said, sir, you're in charge of this walkway. Is that correct? Yes. And your job is to maintain it and to ensure that it's in a safe condition. Is that right? Yes. Are you aware, or were you aware that this condition existed before the day that my client fell on it? Yeah, I was. Well, yeah, that's news to me, right? Obviously wasn't prepared for that. Okay, well, tell me a little bit more about that. Oh, well, actually, just about a month and a half before, my mom had called me and actually told me that the area was in need of repair. So hold on a second here. So you're telling me that a month and a half before my client tripped and fell and suffered 2 spine injuries that required surgeries, your mom called you and told you that this needed to be repaired? Yeah, that's right. Obviously, I look over and the defense attorney is like shrinking to the size of like this small. So, okay, well, what did you do about it? Did you do anything? I mean, here's your mom, right? At this point, she was an elderly lady. I said, well, she told you that it needed to be repaired because it was dangerous. Is that right? Yeah, it was dangerous. It absolutely was dangerous. Do you agree that it needed to be repaired? Yeah, it certainly did need to repair. Did you repair it? No, I didn't. Well, why is that? Now, this happened to be at an outdoor area, walkway, that which they had a duty to maintain. Well, there was a tree. The tree had uprooted this walkway, Mark. I said, okay, so what does that mean? Well, unfortunately, this isn't Key West, okay? Trees, swear to you, trees are more important than people. I said, is this guy really testifying to them? Is he legitimately saying to me on the record that trees are more important than people? Yes, Mark, gumbo lumbo trees here in Key West are more important than people. I said, I just need you to say that again, because I know that we're here, there's a court reporter. I just need you to memorialize it again, because I feel like I'm misunderstanding it. No. I didn't repair it. I didn't ask to repair it. I didn't do anything, because trees are more important than people. Okay. Well, meanwhile, we conclude the deposition, and let's just say that the case settled very shortly thereafter for a very significant recovery. So never take something for granted. Never take them at their word, and make sure that you depose and ask all the questions that you need, because you never know what kind of response you're going to get.